What I'd like to do is just give you a little bit of context to the development of the timeline. It's actually 10 years old. We put it together in 2007 under the auspices of the old National Centre for First Nations Governance, which, interestingly enough, has its strange, unusual colonial history too. We were certainly impacted by the very system that helped create it and also end it. And of course, we transitioned from the old National Centre to the now new Centre for First Nation Governance, and we don't rely on any of the support from the colonial system that undid us in the first place. We had embarked on a rather large research project back in 2006, and we produced a number of papers around the inherent right to self-government and the rights that we have as Indigenous people. And out of that also emerged a need that, how are we going to teach our people about what happened? And what did happen? What is the history behind it? So with the work of a great number of people that were associated with the center, we developed the timeline, the Inherent Right for Self-Government timeline. And I'd like to acknowledge Ken McNeil for the writings he did on putting that together. I'd also like to acknowledge Sarah Morales, who isn't here today, unfortunately. She's with the University of Ottawa. A legal scholar in her own right from the Halkamilam speaking people on Vancouver Island, for also putting together some work on the whole notion of consultation and accommodation. It isn't reflected in our timeline. I'll address it very briefly, and I know that, of course, Kent and Satsan will be going into a bit more detail on it as well. I want to acknowledge also Len Hartley for the work that he and his group, through Hartley Communications at the time, did on the timeline. That was Len Hartley and Mike Guy. We have this online on our website. It's interactive. We also have a downloadable PDF version, and we take that out to the communities. And it's been designed in a way where it's visual. So when we go out into the communities, we bring it up and we walk through it in a fair amount of detail with the community. We spend a fair amount of time on it. I am not going to do that to you here today. I'm not a lawyer and I'm not a historian. I'm going to race you through it. I'm going to give you not the Cole's notes, but the Chris's notes version of the timeline, because on a PDF version it's 30 pages. There's only 9 slides here, but there's a tremendous amount of information. And I'd also just like to call out that Satsan and certainly Kent, if I miss anything on a slide that you think is worth mentioning, do please leap in there and add that. I'm hoping to get through this in about 15, 20 minutes. There's a lot of information here, and I would certainly encourage after, if you're interested in exploring it further, just get online and checking out the timeline yourself. Okay, so the timeline basically covers the inherent rights of today's First Nations, the erosion of our government rights and property rights, and as well the reaffirmation of those rights under the Canadian Constitution and in the courts, and the reaffirmation with the help of many academics and legal scholars, but most particularly that affirmation came about through the tremendous work of many previous leaders and even current leaders today. Next slide, please. So prior to the Europeans arriving in our lands, we were essentially sovereign nations with exclusive cultures, exclusive laws, economies, governments, languages, and exclusive territories. We had property rights. We had civilizations. We were a very populous group of people, very diverse across the continent, down to Central and South America, of course. Recently, there have been a lot of population studies, and it ranges, but we were incredibly numerous, far more numerous than the notion of terra nullius indicates that we were, and that gave justification to other countries coming in and taking over the lands. The inherent right of self-government emerges from the sovereignty that we exercised before contact, and the Aboriginal inherent right to the lands and resources are inherent because they predate that colonialization. It's everything that emerged that was there before the arrival. Next slide, please. Okay, so contact to 1700. This was, I just want to make sure that the PDF's a little different than the timeline. I'm working off the PDF here. So this period was generally of mutually beneficial coexistence. There wasn't much of an impact on the sovereignty or the land rights, on our land rights. When asked to establish settlements, the Europeans generally sought permission to do so from the recognized nations that they were engaging with at the time. There wasn't any loss of sovereignty to us. There wasn't any loss of land rights. We accorded them the right to stay in a certain spot and conduct their activity while we conducted ours. But there's no question that the fur trade that exploded at that time, the introductions of tools and weapons and diseases did impact our way of life, and of course relations between our nations as well, between that of First Nations. Next slide, please. So from 1700 to about 1763, increasingly, from our perspective, there was no question that the guests that came into our territory were here to stay. They weren't going to go. That being the case, then, it was necessary to apply certain rules, certain agreements, and treating among us as First Nations was a common practice. Therefore, we also treated with them in order to have a relationship where we could exist mutually, independently, and respect each other's sovereignty. This was the period of nation-to-nation treaty relations, and these treaties retained the independence, and no authority was surrendered or ceded. We had I believe the Two-Row Wampum, and also the Mi'kmaq Treaty that was signed in Boston in the 1700s were examples of that, the peace and friendship treaties. Next slide. So there was the French and Indian War, and then the resulting Royal Proclamation of 1763. That particular war was won by the British, and following their victory of that, of which certain First Nations allied with the English and certain tribes allied with the French, the Royal Proclamation, it protected our land rights by prohibiting settlement on or purchase of those lands by private persons. The transfers of those lands could only be to the Crown under the Royal Proclamation. But the Royal Proclamation of 1763, this represented a fairly substantial change in Crown policy from one of mutual coexistence to one of protection and viewing us as subjects to their jurisdiction. And why did that happen? Why was there this shift from the respect of sovereignty now to one of protection, one of subjecting us to their rules and policies? A lot of that had to do with the Crown no longer needed us as allies against, at that time, the French. And the impacts of those wars were not only felt by the Europeans on either side that were occupying our territories, the impacts of those wars were hard on our communities on both sides, regardless of which country that you were on. War is a devastating effect, notwithstanding the disease, notwithstanding a number of other factors. A lot of our communities were devastated and torn apart at the time. And that changed the entire landscape for our nations. Now, for us being out in the West Coast, this was happening elsewhere. We weren't quite impacted. But this is all leading up to how we all share in common events that happened 200 to 300 years before they necessarily came out to where, for example, a number of us in this room are from. So next slide. So this was the period of land cessation that largely emerged under the Royal Proclamation of 1763. First Nations could still govern internally with their own systems, but sovereignty was slowly being whittled away by the Crown, and further jurisdiction was being asserted over us, quite often in violation of those nation-to-nation agreements that had originally come about. Next slide.
I think we might be a bit ahead.
Oh, am I?
Of you. Yeah. So we're at 1867.
Period 5. Yeah, shh. Okay, okay, so from Confederation to the 1927 Amendment. Yeah.
Is that right?
Okay. So where did I jump?
You're there.
No, I'm there. Yeah, okay. Oh, I see. Okay. Yeah, I haven't got control of the clicker here. So by 1867, in the creation of Canada, Parliament got exclusive jurisdiction over Indians and their lands under the BNA Act of 1867. Shortly after that, Parliament started enacting legislation exercising full authority over First Nations. By 1876, all the laws that they had passed enacting that authority were consolidated under what we now have today as the Indian Act, although it's been amended quite a few times since that period of time. The legislation gave authority to the Crown to replace traditional governance with elected chief and councils, but there's an important point in all of that. That legislation didn't outright abolish traditional governments. Many traditional governments did continue to operate rather covertly, and there's a number of examples. I don't know much about the examples in the prairies or in eastern Canada, but we know that on the West Coast, a lot of those systems stayed intact, but very much under the behind the closed doors from the Indian agent and from the Department of Indian Affairs. From the late 1800s to the 1920s, 11 numbered treaties were entered into. None of them dealt with self-government. None of those treaties dealt exclusively with self-government, but the Crown still applied the Indian Act in most of those cases when organizing those particular treaties. The last treaties entered into were in 1923, and what effectively ended treaty making was, as they marched across the prairies and into BC, we did have at one point 12 treaties that were negotiated by Governor James Douglas in the early 1800s, and then part of Treaty 8 in northern BC. But in BC, BC refused to acknowledge the notion of any treaty making whatsoever, and in fact put pressure on the Crown to put forward amendments under the Indian Act outlawing the ability for First Nations to retain a lawyer or to raise any funds to advance claims for resolving land issues. That also included making treaties. So in many respects, this had the unintended consequence of stopping treaty making and affecting how First Nations, particularly in BC, approach their title and rights today, as is seen by the numerous and victorious Supreme Court decisions that result from BC-based actions. So that's just a little irony there, is they may have stopped it, but for many of us, we still have title to our land. We never seceded it, we never gave it up, we never treated it. And that has had a huge impact on the way that we look at our title and rights today. We just never gave it up, and we're pursuing it relentlessly. Next slide, please. So 1927 to 69, the infamous 1969 white paper. So the prohibition on pursuing land claims was removed in 1951, and in 1960, status Indians were given the right to vote. And then along came the notorious 1969 white paper and its attempt to assimilate us into the mainstream largely just stirred the pot further and certainly emboldened a lot of our leadership to plunge forward and embolden us to assert our rights and very aggressively pursue justice, really, in the wake of wanting to eliminate us and absorb us into the mainstream of Canada. Next slide. So in 1973, the Supreme Court of Canada came extremely close to deciding on the existence of Aboriginal title, and that was as a result of the Nisga'a up north in BC advancing the Calder case. And although this was a split decision of the courts, I believe 3 in favor, 3 against, and then 1 on a technicality with regards to a fiat as to whether the Nisga'a could actually sue the federal government. This was enough of the implications to that decision, the implications to coming so close to deciding the notion of Aboriginal title, was enough to force the Crown to reassess their refusal, their historical refusal to recognize our title and rights. It was enough to propel them into some policy decisions, and from that emerged the comprehensive claims and specific claims policy. It was also the start of the very slow process within the Crown to put forward certain systems that would acknowledge some of the gains that we were slowly making in the courts. The next key element that emerged at that time too was the repatriation of the Constitution. And our leadership certainly pushed for Section 35 in the repatriation of the Constitution in the early 80s. And that's been quite paramount in influencing the political and legal dialogue of our Aboriginal rights since 1982. Next slide, please. Okay, so in the 80s, there were 4 conferences that were held between ministers and our own leadership on defining what Section 35 was. That was the whole notion of the empty box, as Satsan had referred to. 4 conferences on what does it mean, and they never came about really defining what it was. However, at that same time, there was quite a lot of legal groundwork being broken because of the very existence of Section 35. And legal groundwork, particularly on the Crown's obligations to reserve lands and dominion over us as a people. There were court cases that emerged, the recognition of fishing rights, such as the Sparrow decision, the Crown's fiduciary over our people with regards to particularly Garin at Musqueam. The courts were increasingly being used, and particularly by us, in the wake of the Calder in Section 35 as the go-to for clarity on the direction of our rights and title. Other court cases emerged as well, for example, Regina versus Sui, the recognition of historical treaty relationships. The BC treaty process emerged in the early 90s, and that was an acknowledgement rather than a denial that something had to be done. And then, of course, the Meech Lake Accord, although it failed within it, it would have provided for explicit recognition and implementation of the inherent right of self-government. Aboriginal rights, including the inherent right of self-government, would depend either on court decisions or negotiated agreements in the future. So, next slide. So really from 1992 on, this represents the apex in the development of Aboriginal rights. No less than 20 cases have been brought forward that have also rounded out the entire definition of rights and title. And above all, key to this is recognition of rights and title. And I won't go through all the cases. On the website, you can drop down and explore significant cases. There were 3 here that comes to mind. Delgamuuk, for example. You know, the deciding that Aboriginal title is a property right. Aboriginal title can be established by proof that the land was exclusively occupied at the time of Crown assertion of sovereignty. That Aboriginal title is one of the Aboriginal rights recognized and affirmed by Section 35 of the Constitution. That Aboriginal title is under exclusive federal jurisdiction. And acknowledging that decision-making authority of Aboriginal nations have over their community. And also the recognition of oral evidence. So that's the key areas of the timeline. To add to that, we have the duty to consult and accommodate, which emerges from Section 35 and 3 key Supreme Court decisions. So proving Aboriginal title or negotiating a treaty may take many years. And in that time, resource and development activity can take place. So what happens to a First Nation that engages in either trying to prove Aboriginal title and or gets involved in the treaty-making process? That can take considerable time. And in the meantime, development interests are going into the territory and removing a lot of the resources. So the value of those resources diminish quite considerably to the First Nation. What are the protections there for a First Nation? Well, Section 35 and the courts have decided and set out a series of obligations of the Crown before they can do that. And those are key areas that a lot of First Nations need to practice, need to insist on taking place, and that the Crown and even industry are obligated to in order to protect your lands during those periods of time. I won't go into detail on the cases. I'm certain that Satsan and Kent can expand on them as well. And that concludes the brief history of our self-government from pre-contact to present. The only thing that we need to cap it off with, as you can see, we've gone from a period of sovereignty through the suppression of our rights to the reaffirmation of them. What we'd really like to finish it off with is stepping straight back into the practice and the implementation of self-determination. And that's where we need to go now. Thank you. Okay.
Can everybody hear me? I have a quiet voice. Okay. Great to have been invited to this. Once again, I'm Jodi Bruhn. I'm actually a private consultant. I'm the only consultant in the room. I take that as a great honor. I will behave. And I was enlisted to help update the timeline because from what I understand, the center had funds only to basically do up to the end of the duty to consult and accommodate. And I believe that Francis wanted to enlist me. I had spent some time at the Library of Parliament and within government, a little too much time in government, 3 years, that did me. And I was close to some of the developments that happened then quite recently, and I think that I'm in a position kind of to comment on them. So we're going to talk about 4 cases, and we're going to talk to you about a piece of legislation that I think might be interesting, that might get too little attention within academic circles, but is potentially a way to help manage that transition out of the Indian Act. So the 4 cases are the Chilcotin decision, the landmark title decision, Louis v. Louis, which is a BC Court of Appeal decision, Deschenaux 2015, that deals with Deschenaux v. Canada, the status rules, and the change to the status rules under the Indian Act that has to happen in order to comply with the Charter. And then Daniels v. Canada 2016, which really challenged the notion from the side of the Métis and the non-status Indians of who is an Indian under Section 9124 of the Constitution. Okay, Chilcotin, I'm not a lawyer either or a historian like Chris. I'm a political scientist. So maybe the lawyers in the room might want to help sort of enhance my understanding here. But it really was a watershed, right? It was a watershed decision to try and give some more sort of substance and more interpretation to the earlier Delgamuukw decision. And it was a clear sort of repudiation of the doctrine of terra nullius. Aboriginal title was recognized as being not simply sort of site-specific small pieces of land, but actually in the case of the Chilcotin decision encompassing almost 2,000 square kilometers. There was more definition given to the notion of ownership and what is entailed in the ownership of a title, that it is possession and ownership rights, that consent is required in order to proceed with development on the land. And it raised the bar, too, for the justification for an infringement or an incursion on a title, that there had to be a compelling and substantial one, and that it had to be done, any infringement, in a way that was consistent with Section 35 of the Constitution, that would promote reconciliation, that would take into account the views of the Indigenous group. And it set a much higher bar for the kind of work that has to go into getting consent. The case significantly alters the legal landscape relating to land and resource entitlements and their governance. That was the estimation of one of the commentators, Mandel and Pinder, on the case. A question I have, did it actually go so far, though, as to recognize pre-existing Indigenous sovereignty? So I'll leave that open for Kent. To my interpretation, it did not. That, you know, the kind of title recognized did not, but maybe I misinterpreted it. The other question I have is, I mean, how much use is this to First Nations that already have treaties? So we're talking about Aboriginal title here. That's what the decision was about. In cases where title had already been treated, how useful is the decision to, for example, Prairie First Nations within the numbered treaties? Okay, moving along. This is a question. This is now the area of Indian status. The 3rd time now that the Indian Act is found to violate Section 15 of the Constitution, the Charter of Rights and Freedoms, equality between genders. The problem is, when Bill C-31 was introduced in 1985, there was pre-existing gender discrimination in the Indian Act that was never addressed at the time. Still hasn't been addressed. There was an amendment made to the Indian Act in 2010 in the wake of the McIver decision that found that there was discrimination, and the amendment to the Act addressed that small segment of the population, very much like the situation of Sharon McIver and her children, but it didn't address all that it needed to. The Deschanel case, 2015, found again that there was still this residual discrimination in the Act, and to date they haven't been able to arrive in Parliament at an amendment that will satisfy both houses. There have been senators who have said, no, the amendment as proposed by the Government of Canada is still discriminating against the children of this certain group of women, and we want to actually amend the rules in a way that it will deal with this gender discrimination problem once and for all. There's an impasse right now at Parliament. They still have to bring forward a bill that will satisfy both houses, and it's not clear that that's going to happen anytime soon. So the implication, though, is that there's a potential here, if this issue is addressed, that there's a real widening of the group of potential people who can have Indian status. And it does underscore the need, too, for First Nations to try and sort of take the initiative in defining who we are, who our people are. Because it really is, to some extent, out of your hands what's going to happen now with status. And the lawyer who's working with, I think his name is Dion, or Schultz. There's a lawyer, I mean, the litigation will be a battering ram, I think, until it's dealt with. So that's something to keep in mind as you think about defining your nations. Now, Louis v. Louis, I think that possibly Satsang can speak better to than I can. But it's a decision of the BC Court of Appeal that really highlighted, it was about management of Indian monies under Section 69 of the Indian Act. And the band in question had not put in place financial management rules and controls and bylaws that would enable them to do it in a way that was transparent to their community. They hadn't made those, they hadn't passed those bylaws, and it was found that a decision they'd made with management of their monies was in contravention of the Indian Act, and they had a fiduciary obligation to their members, which they had inherited in taking over financial management under Section 69. And it really reinforced that the Band Council is a creature of the Indian Act and has no authority or existence beyond the Indian Act, which once again is a reminder, I think, about the nature of Indian Act governance versus, and the real distinction between that and governance that's based on the rights. Daniels v. Canada. This is the last case I want to discuss. This was a 2016 Supreme Court decision, which was very, very consequential, I think, for all Indigenous peoples, in particular for the Métis and non-status Indians who had been in this legislative sort of in this limbo. But there was a finding that the federal government indeed has jurisdiction over all Indigenous people in Canada, including non-status and Métis people, that they qualify then as Indians under Section 9124 of the Constitution, and that the Crown has a fiduciary relationship with all of these groups and a duty to then negotiate claims and settlements with Métis, as well as groups that are not recognized as Indians under the Indian Act. So this is new and this is big. The effect is, too, there's a question as to whether Métis, non-status Indians, are also entitled in a way to some of the programming that First Nations now receive, that Inuit now receive, and there's a potential then to add a lot of people to this definition. So at the same time, so you're talking, I think the message here is there's a simultaneous gaining of precision and depth in our understanding of what are Aboriginal rights entitled, what are our Section 35 rights. Like you said, Satsan, I think like the box is full now, and there's more precision there. At the same time, there's a sort of diffusion a dispersion of the understanding of who is an Indian, which is potentially quite appropriate because it's a legal fiction in the first place, correct? It's a legal fiction that was created by the Constitution of Canada, by the Indian Act, and it's being hammered at by the groups who had been excluded from that definition quite properly. And the question then is, what can you do that really tries to bring you to this place where you're determining your own people, your own laws, and how you're going to govern yourselves, as opposed to being part of this regime which was created in the late 19th century and which really doesn't reflect who you are. I wanted to talk very briefly about something I think gets overlooked a lot in the academic literature. And I think one of the ladies who was speaking earlier mentioned you were developing a land code. And there's was it with regard to the First Nations land management regime framework? Okay. So there is this legislation which was pressed for by some First Nations within British Columbia throughout the 1990s. 14 First Nations were the initial signatories. But the effect of the legislation, effect of the framework agreement, which was initially negotiated, and then the legislation that was federal that was subsequently passed, is once a First Nation signs onto it, once they develop their land code, they are in effect free of 1/3 of the Indian Act, those pertaining to land management, land development. Although it's called the Land Management Act, it is, practically speaking, jurisdiction and real sort of lawmaking power under this act. So there are 95 First Nations on the schedule now. There's a process in order to become part of it. It used to take longer than it does now, but it's supported too by a First Nations-led institution, First Nations Lands Resource Center, and they really assist First Nations in developing their land codes. So I just put that up there as potentially one of the transitional kinds of measures, a path out of the Indian Act. And there was an article in Policy Options that said, like, look, we have 95 First Nations taking part in this. How many have taken part in self-government agreements? How many have completed their self-government agreements? Just really sort of comparing the time that you have to invest in order to leave, which is actually a pretty significant chunk of the Indian Act. Question?
Yeah, when you refer to the land code, I didn't vote for it because when I read it as only agreeing to taking that part within what we call our reservations. And I saw that it might be a possibility of ceding any rights to our traditional territories. Is that true?
That's a good point. Yeah, it does refer just to the reserve lands.
So,
Yeah.
So I was afraid that if that happened, then we're just saying, well, this tiny little piece here, that's what we have rights to. And by somehow doing that, that would be signing away all the rest of it. That was my thought.
Yeah. No, that's what it is about. It's about reserve land. So it's about the Crown land. It's taking over management of that piece of the land. And definitely, you raise a good point. I mean, it's still very much within the old box, but on the other hand, it does get you out of 1/3 of the Indian Act with regard to that piece of land. So it could potentially be seen as a stepping stone. I think that some leaders have cast it that way. And for others, it doesn't work at all. I just wanted to mention it as something that seems to have been popular with First Nations that might be one of the blocks or one of the pieces that help get you from this column to this column. So that's it for my portion of it. If you have any questions for either one of us, then there are a few minutes.
I think it's really important. Microphone, please. Sorry.
There's that mic, Chris.
Thank you. I got him. I think it's really important to mention, too, that We didn't go for the land code because of, like Mo said, it's a trust issue. We didn't want to give up our rights to our traditional territory. And I was actually really proud of our people for taking a stand to make sure that our nation didn't go ahead with this land code without the people. Like, you can't go ahead without the people. And right now, like, we have to really work on the trust issue, and there is a trust issue there because we don't trust the Indian Act governing system that's in place right now. Yeah, it's more important for us to go ahead with our inherent rights first. Mm-hmm.
Thank you.
Thank you.
So what you're speaking to, too, is the requirement to have a ratification vote on the land code when it's developed. And in some cases, it doesn't pass. You're correct. I mean, it's, the other thing I would add, it doesn't preclude claims. It doesn't negate the ability to make a claim subsequently or to proceed with self-government agreement. But I can also see why you would think, well, why are we messing with this at all when what we really want, we want to keep our eye on the prize and to sort of transfer to our focus to our entire traditional territory. On the other hand, I do know some First Nations, I think there's one in Saskatchewan in particular, that are very happy that they've entered into it. I'm not trying to sell anything here. It's just something that I come across a lot in the work I've done with government and with some First Nations that really hasn't been addressed all that much yet by the academic community.
For my community, is this one?
It's Akwesasne.
Yeah. So for my community, when I'm listening to you speak of the land code, and then I know you just spoke of the First Nations Land Management Act. So for me, those are two different things. So we had the First Nations Land Management Act come to our table and have discussion, and we had discussion. We went back and forth. That's this side, and then over here, we're in our final negotiations for our self-government agreement, and we're working on our land code. So when we sat there and we weighed the good and the bad, we were prepared to stick it out with our land code, because at least in our code, we could negotiate. The Land Management Act was, here it is. Here's the money that comes with it. That was the enticing part, but that money wasn't going to stay. In the land code, as part of our self-determination, self-government agreement, we will now work towards what that money will look like, or that funding will look like for us to determine our lands, and it won't be restrictive. So when you want to look at the difference between the two, one is an act and you're creating your own land code that's part of your self-government agreement. So we said thank you, but no thank you, and we're going to stick with our code. There is also, as you mentioned, there's the possibility that it may not be accepted by the community. But that goes back to the education and the engagement you do throughout the process. So when it comes time for the ratification, you're hoping that you've done your job to get them to have their input, to engage in the process, and to accept it. But it is indeed not a short process.
Could I ask you what the threshold was, too? It's quite high, isn't it? Of the people, you have to have the proportion of the population that has to vote in favor.
We're still negotiating it.
Okay.
Thank you.
Yeah, I just wanted to, this whole Land Management Act thing is really misunderstood in our communities. People mistake it as having jurisdiction as opposed to delegated authority from the minister, which is, those are very different things. And that's practically all you're getting, is the minister delegating authority to you to make decisions about how you're going to manage your land, so that you don't have to wait 5 years for the minister's approval, whereas the council can do it tomorrow. they have a good business opportunity or a good reason to do it. So that's what it basically all it is. But in terms of our community, our people totally misunderstand it because there's been no education around it. And the Land Management Act is limited, I think, in terms of its scope of being able to do well and good for some communities, because it comes down to location, location, location. For example, Chief Louis from West Bank was the man who led the charge in the creation of the First Nations Land Management Act, which he needed in his community to develop the lands that they had. So it made sense for them. Whereas my community, where I come from, 3/4 of a square mile of a reserve, most of it canyon land, like we live on a river, there is no economic development to develop there. There is no reason for that there. So it's been sold across the country as a kind of like a panacea for all your ills. Here, do this and you'll be okay, when in fact it's limited in its scope, and it's certainly not a transfer of jurisdiction. But I think that in terms of the Indian Act and being able to master it to the degree we need to leave it so we're not wasting our time and work on the inherent right, we need to look at all of the vehicles that are available within it and determine whether it makes any sense for us to use them so that we can master it, and so so we can start to transition out of it. I don't see. I think there are vehicles where we could use to make it easier to deal with the Indian Act, but I don't think those vehicles have enough gas to get over the bridge. So I just think that we need to, really be careful how we characterize those opportunities under the Indian Act, because they're not meant to transition into the inherent right. But can we use them to do so? That's important work for us to do.
And just before I leave the podium, I do know of an example in Saskatchewan where that's exactly what happened, that the land code that was developed under the FNLMA was then the land code that was used also in negotiating the self-government agreement. You're absolutely right. Thank you for the reminder. Will this be a good vehicle or won't it be? I think that's the
Well, I think the most important point to make is that this does not apply to traditional territories. That it's just strictly with the reserve, and that distinction is critical.